Hello and welcome to the Micklin Law Group's webinar series. Good evening. This is Attorney Brad Micklin. I'm the managing member of the Micklin Law Group. Today's webinar is Men's Alimony Laws in New Jersey, Their Transformation and Evolution. First, let me give you a little background about the webinar series itself, and then I'll tell you a little bit about what the purpose of this one is before we jump into the context. I started doing these webinars, and I used to do them on a monthly basis. Now I do them every other month because I think it's better to spread out a little content. Because I discovered from meeting with clients over the past 20 years or so that there's a tremendous amount of information that a client needs to know about one's case, and it's impossible to give it to them in a 1-hour consultation. It's almost impossible to give it to them throughout their entire course of their cases. So I decided to start this webinar series along with my daily tips that I put on my YouTube page and a how-to series I do also on my YouTube page, which is Brad Micklin if you want to subscribe, so that you would have a wealth of resources that you could go to and access, whether you work with my firm or on your own or even with another firm, and get the information that you need so you'd be better prepared not only for your matter, but even for questions and issues that may come up. You have a better sense of what you don't know once you have some information behind you. The purpose of this webinar is my firm is concentrated in men's and fathers' rights in divorce, custody, and family law issues. And part of the reason why I focus in these areas is I believe that in many cases men have been disadvantaged historically in the family and divorce law areas, especially in areas of alimony and child custody. Now, fortunately, the laws have changed significantly and rapidly in these areas most recently. But I don't think the mindsets of litigants and many judges have changed or come up to speed with these changes. So I changed the focus of my law firm into men's and fathers' rights so we could bring this awareness to the litigants on both sides of the case so that, for instance, both mothers and fathers or same-sex couples would understand that it's not traditionally just the mother or the stay-at-home parent's right to have custody. It's now an equal shared arrangement, things like that. So this is one of the first webinars to actually start addressing men specifically in these areas, and in the alimony, and also cover some of the new alimony changes because there's been a lot, not recent changes, but there's been a lot of changes in the last 4 or 5 years following the last amendment to New Jersey's alimony statute. So let's jump in and start giving you a little information about what we're doing here today. This is me. In case you don't know me, you're not working with me, or may not have met me. My name is Brad Micklin. Again, I'm the managing member of the Micklin Law Group. Here's my background briefly. I'm a member of New Jersey State Bar Association. I practice, I'm licensed to practice both state and federal courts. I started my career as the law clerk to Judge Eugene Austin, the supervising judge of special civil. Then I moved on to Kessler & Associates, where I did complex commercial litigation for a number of years. Found I didn't care much for representing companies. I like dealing with people, and I opened my own office in, I think it was 2001. At that time, I was a general practice attorney, and then I quickly focused into divorce and family law, and now I moved into men's and fathers' rights in divorce, family, and custody matters. We do have several associates. I do the more high complex, high net worth, and high conflict cases. We have a number of associates that also assist me on our cases on a need, depending on the needs of each individual case. Here are some of the words I've been honored to receive. Fortunately, I've actually been honored to receive many others beyond these. This slide hasn't been updated, but most of these awards that you see I've also received a number of years. I don't put this up to impress you, but to impress upon you that I'm confident in the materials that I'm presenting and in my care and concern and ability to help you, so you know that you can trust what you're hearing from me. Quickly, a little bit about the webinar that we're going to have, just how it works. It's set to be 40 to 50 minutes. I schedule for an hour, but I try to leave some time for questions. As you should be able to see right now, it's a one-way communication. I'm assuming you can hear me. I will not be able to hear you no matter what you do with the control panel that you have. There is a handout for this webinar. It should be towards the bottom right side of your control panel. If you want to download it, we will be talking about a lot of the statutory criterias and cases, so you might want to have it as a reference afterwards. I will be taking questions. I don't do them during the webinar because I like to keep the flow going, What you'll see on the bottom right of your control panel is a place for questions. I would open that up and type in at any time a question comes to you, even during the webinar. It won't interfere with my transmission, and it'll be there so that when I get to the end of the webinar, I can then go and answer all the questions. And I'll stay as long as I need to address any questions, so you don't need to worry about time on my end at least. Real quick, I do a divorce and custody support group for men. I do it usually the last Wednesday of every month at 7 p.m. at my office, 187 Washington Avenue, Suite 2F in Nutley. I'm considering making that either an online community instead of in my physical office, or both, allowing you to either appear by webinar or phone or come physically into the office. Right now, it's a physical support group where we meet in my office. If you'd like more information on that, just give us a call. You should have my number if you register for this, but it's 973-562-0100. Again, that's 973-562-0100. So without further ado, let's talk about what we're going to cover today. And I'm going to cover a lot of information, so I'm going to do it fairly rapidly and with as few comments as I can so that you really get the important information. I'll put my comments in where I think they're relevant, but it's more important that you get the basics from this. So first, we're going to talk about the recent changes. I mentioned a moment ago, the alimony statute was significantly amended in 2014, and it attempted to codify a lot of the changes that the statute or the legislature believed was in practice, but not in the statute. I don't know if that's really true or not, but we'll talk about the types of alimony because the alimony reform statute did create new ones and terminate other ones, so you might have a misunderstanding of what the types are available. We're going to talk about the factors for the majority of the most common types of alimony, so you understand what you may need to prove or disprove, how to modify and terminate it, and then a big issue is going to be cohabitation. The statute did change that, and it is a significant issue when there is an alimony obligation. So let's talk first about the recent changes. As I said, there was a significant, actually I didn't mention this yet, but this webinar is being recorded in March of 2018. We are on the cusp of going into 2019 where the new tax code revisions are going to take place. And one of the most important is that what used to be deductible for alimony is now not deductible, effective January 1, 2019. Now, if you are divorced by December 31st, 2018, or if you have been divorced at any time prior, alimony will still be deductible. It is only for alimony obligations that arise after January 1. And it's going to be a significant change because, well, I'll get into that in a second. There's a couple of things to talk about this deductibility first. An important note that I don't know if a lot of people are aware of is it changes the deductibility on the federal level, but not on the state level. So you're going to get some deductions and you're going to lose some deductions, which is going to complicate how to do the calculations in practice. Now, here's the consequences. It used to be that the higher earning spouse, who would obviously be the one paying alimony, would receive a benefit of being in a lower tax bracket. Sometimes by paying out alimony, their income is dropping, their tax bracket is dropping, and their tax payments are lower. So it would allow for more disposable income. It was sort of an income shifting statute. And now that the deductibility is gone, we're using net income and there's going to be less money available. So it's going to be significant. Child support guidelines are also going to be calculated differently because currently they take into effect the deductibility of alimony as well as dependent deductions and other deductions, which have also been eliminated under the new IRS code revisions. All your personal deductions are being eliminated, or most of your personal deductions are being eliminated. And child support guidelines historically have calculated these tax effect changes into its calculations, same as we did with alimony. So now, basically, the conclusion to draw here is all of the attorneys and all the lawyers that have been practicing for the last 20, 30, 40 years now have to create and understand new ways of calculating alimony and child support in ways we never have before. So you need to be ready for it. It might be very challenging. Another issue that is going to come up that not many people are speaking about is it's the effects on prenuptial agreements. If you had a prenuptial agreement and you still have your spouse, you're still married, your prenuptial agreement was probably drafted under the understanding that if there was an alimony obligation, it was going to be deductible. So now it's not going to be. Your agreement itself may be unfair to one or both of the parties, and you may need to revisit it. Just one second. All right, so let's talk about some other changes to the tax code. As I was starting to talk about, the personal deductions are all gone. Not only is that relevant to the child support and dependent deductions that I mentioned, but also in a lot of settlement agreements, we use deductions like mortgage interest and taxes as a way to shift income to different spouses, and that's now going to be gone. As I mentioned, the dependency deductions are gone. And one other significant change is the tax code income rate for pass-through income from a business. I won't go into that in depth because it's too broad for this topic, but if you have a business and you're going through or maybe going through a divorce, you need to meet with a tax attorney or your accountant to understand how these tax code revisions are going to impact you as you move forward. So now, as I mentioned, the alimony statute was amended in 2014. So let's talk about some of the things that these amendments changed. What I was talking about before was just a change in the tax code. It had nothing to do with the alimony changes. So first, it removed permanent alimony. The problems with permanent alimony is that it truly wasn't permanent because any change of circumstance or significant change of circumstance like retirement, loss of employment, disability, would trigger a review and possibly an elimination of it. So permanent was never really permanent. So they replaced it with what's called open durational, which I have a small pet peeve about this because I don't believe the word durational is actually a word, but it is now because it's in our statute. So in order to replace what was permanent, they said that a marriage of less than 20 years cannot have alimony longer than 20 years. Now, many people believe that that means you can only have permanent alimony if it's after 20 years, or even alimony that lasts longer than the marriage if it's after 20 years. But remember, the statute says for a marriage less than 20 years, alimony cannot be longer than the term of the marriage, which means if you're married 10 years, it can't be more than 10. If you're married 15, it can't be more than 15. So everybody concludes that after 20, it means you can have it for more than 20. But the statute doesn't actually say that. It's an ambiguity that's going to eventually come up because if the legislature intended that, they would have written it that way, and it's not written that way. So be prepared if you're on the opposite side of that argument. Cohabitation has been defined and codified. There was a lot of practice with judges and lawyers about how cohabitation was litigated, so they put it into the statute to eliminate some of the issues. They defined the marital standard of living to apply to both sides of a marriage, meaning it used to be the higher earning spouse would have to keep the lower earning spouse in what's called the comparable standard of living. But when one has to pay for the other to lead a comparable, then the first one who's paying doesn't lead a comparable lifestyle. So there was an unequal balance of how support was being paid and an unequal lifestyle. That's now been, at least in intention, equalized. They reduced the 90 days of permanent change of circumstance. It used to be 6 months before you could file for a change of circumstance, meaning if you lost your job, you had to wait 6 months before you could file, which was devastating to most people because now you're 6 months behind in support before you even get the court to look at it. It's been reduced now by 90 days. They put in special provisions for self-employed individuals. There's a different standard now. You need to be able to show the economic benefits, economic and other benefits, perks and things like that. And you also need to be able to show how that is relevant to or related to compensation if you've switched jobs or if you're in a new job. So, but the short part of it is it's not just an income analysis when you're self-employed, but it's They're looking at business perks and other advantages. They made several changes around the issues of retirement, and now there's a good faith presumption at 67 that you do have the right to retire. Historically, you were in a catch-22 when it came to retirement because you would have an alimony obligation. You'd want to retire, so you'd file beforehand because you didn't want to retire and not change your alimony, so you'd file. But then they would say there's been no change of circumstance because you have not, in fact, retired yet. But then after you retire and you give up your job, you file the motion. If you're unsuccessful, you have to keep paying alimony and you gave up your job. So now there's a presumption at 67 that it's a good faith of retirement. You should be able to. There's also anticipatory retirement that's allowed. If you can show that you are planning to retire and it's a good faith of retirement, the court will consider that so that you're not stuck in that catch-22 that I described. Now let's talk about some of the types of alimonies. Not only types of alimonies awarded, but the different types or different times inside your litigation. Your first one, or your earliest one, will be your pendente lite alimony. Pendente lite is Latin for while the matter is pending. It is generally going to be awarded in the early stages of a divorce case, and it will carry throughout the divorce process. One of the most important things that you will have to do for that, oh wait, I'm sorry. I had the wrong sheet. Part of the problem in the pendente lite, which went to why they codified that standard that the life's comparable standard of living applies to both, is there had been a serious bias in the pendente lite's award where women would receive it more than men. It was almost unheard of for a man to receive pendente lite support, even when there was a severe discrepancy in income. There's also times then and now where a man would lose his job and it would be viewed as divorce planning, and they would impute or inflate the income. So if you are going to be in that situation, you need to start keeping records to show your job efforts, jobs that are available, because everything is done online now. So you need to print out what has been available, what you did search for, and what you did interview, if any. If you are self-employed, as I mentioned, now the standard is different. I usually recommend that you keep and go back for at least 5 years of records so that you're prepared in case you are going to be going into either a divorce case where there's going to be an alimony claim, or if you are in one that you may be seeking a modification, which we'll talk about modifications a little later into the webinar. But this information here is going to be helpful whether you're starting a case or even if it's post-judgment. So now going on to some of the information and factors about early alimony. So like I was saying, pendente lite alimony is your early stages. It will be decided significantly based on your case information statement. Going through this part, I'm going to tell you a little bit about your preparation. When you go through the case information statement, the first important section are going to be your Schedule A, B, and C expenses. There's going to be a joint and an individual column, and a lot of men have a tendency to fill out one or the other and not both, or to fill them both out as if they're the same. It's very significant because the numbers you use will go through as a map for almost your entire case, if not your entire case. So if you don't have it right, you might get locked into a bad support agreement, which is going to set the tone for your entire litigation. But additionally, you're going to get your case information for your spouses, which I suggest you review very critically, not only for inflated expenses, which is obviously the most common problem, but you want to look for places where they believe there might be assets where there aren't. You might even want to look to see if they have assets that they should have been transferring. If they have a retirement account or a bank account, you might even want to consider doing an asset search, because it's very common that a spouse would be stashing away money pending a divorce because they're concerned about support or they don't want to hide assets. It's generally men who are considered the ones who are hiding assets or sending money out, but it's quite common on the other side of that case. But you must make sure that your case information statement is accurate, because it will haunt you through the entire litigation. And if you get a bad support obligation, it's very difficult, if not impossible, to change it. Pendente lite. You will have a duty and an obligation to update it. It's probably to your advantage to do that once you have a little more information, because this case information statement is a summary document, which means it's accurate but not exact. So every month is going to be a little different of what your expenses are, and as you go through the litigation, you might have a better sense of it. because most people don't really know their expenses that well until they're forced to start looking at it. So let's look again more about the penitent alimony and what it's for. It's intended to protect the status quo, which means whatever was happening before the divorce, courts will generally want to keep in place. Now, this is the standard that almost every judge I go before uses, but I don't believe it's actually the legal standard. I think the standard for penitent alimony is the same standard that alimony is. I think it mirrors the statute, but everybody goes by the status quo. And that's important because the amendments state that neither party has a greater right to the standard of living. And a PL order usually does shift that. But as I said when I opened up this webinar, I find that judges are still very protective of women or the lower earning spouse and looks more towards keeping them in a comfortable position than worrying about the man's ability to actually pay the obligation. Now, if you are a stay-at-home parent, that shouldn't mean that alimony, penitent alimony, is just a free ticket to sit through your divorce case. There should be, and I believe there is an obligation to go out and get employment. When I file my responses to defend against a penitent application, I usually ask the court to order a review of 3 months so that we can make sure that the spending is accurate and that the spouse, usually it's the wife, is making reasonable efforts to look for employment. Otherwise, they could sit for 12 months and just get free alimony. The PL, I'm going to call it PL, penitent is referred to as PL, is usually in the very beginning of a case, so it's prior to the completion of discovery, which is the exchange of financial information, which is problematic because it usually means that the numbers are not going to be accurate. And you're going to get a financial obligation that may be based on inaccurate numbers and summary numbers, which is problematic because they're hard to change. Now, there is a case that says that can be changed. It's the Malamo versus Malamo case. That case speaks of retroactive modification, but I've never, ever seen it actually applied other than by an agreement at the end of your case if the spouses agree. But Malamo is supposed to stand for the proposition of since the PL order is entered without the accurate numbers, the retroactive modification is what makes the person whole if they've been paying too much or receiving the wrong amounts. But that does nobody any good because changing the order after months and months after it's been paid doesn't help people. You need to help when you're ordered to pay it to make sure it's the right amount and you can afford it. Tax allocation, I currently ask now, I mean, again, this is going to change coming January, but historically and up through this year, I always insist that there be the right to allocate it for tax purposes at the conclusion, because generally it's going to be considered unallocated, which means it's not deductible at all. So you need to have that just reserved so that you can allocate it if you're getting divorced anytime before 2019. But because of these changes and as well as the difficulty, I always say to seek the advice of an accountant. So let me just get a sip of my coffee. Now let's talk a little bit about the specific types of alimony under the new statute. Well, I guess it's not new, but the 2014 amended statute. First is the open durational, like I was talking about. As of 2014, it replaces the permanent alimony, which means there's no predetermined end date. It's open. Normally, permanent was also considered permanent, but like I said, it did end at certain times, like retirement or disability. Open durational doesn't. But unlike permanent alimony, it does have a statutory catch-all for exceptional circumstances. So when I said before, for instance, that if it's less than 20 years, it can't be longer than the term of the marriage, there is this catch-all that says if there's exceptional circumstances, the court can do it more than 20 years. As far as I know, there aren't any cases that have actually brought that issue to the appellate division yet. The statute's only 4 years old. It usually takes a couple of years for appeals to be completed. So there's probably many pending, but none that I know of that have been decided yet. And again, just reiterating, it's open durational is only for 20 years other than exceptional circumstances. It's presumed to end when you reach the retirement age, which again is 65, but that can be rebutted under certain circumstances. But also it can be earlier, similarly, or conversely for other people. Like for instance, police officers who start in their 20s are eligible for retirement in their mid-40s sometimes. and given the difficulty of their jobs and the danger of it, it's reasonable for them to retire at an earlier age. Many other high stress professions have earlier retirements. So you're not locked into the 67 that I mentioned earlier. That just means if you are at 67, you have less of a burden to prove. It's the other party's burden to prove that you can or shouldn't have to retire. But at any other age, you have like I said, the anticipatory retirement provisions, and they look at it in the industry or profession that you were in. Moving more into different types of alimony, limited durational alimony. This is probably the most common alimony that is usually agreed upon. That's also probably the most common awarded because it's the simplest. It's basically just for a fixed time period, usually a given number of years. The purpose of it is to help the supporting spouse become self-supported. Again, under the new statute, it's not supposed to exceed the length of the marriage. And other than a 20-year marriage is usually what you're going to be awarded. It's, like I said, it's the most common because it's the simplest. Many years ago, rehabilitative alimony was the most common. This too was for a specific period of time, but the purpose of this was specifically to have this low earning spouse reintegrated into the workforce. So the intention was to cover costs of education and training, help with living expenses, so that as you re-entered the workforce, you had some financial assistance. So you didn't have to just take a job at McDonald's, but you could go back for some training. You could take a lower paying job to get experience. But the reason why I think that this is not utilized much, and this may actually come up a little later in the modifications. I think it does. Well, I'm going to talk about it anyway. We'll talk about modification later. But the reason why I think rehabilitative is not used as much anymore is rehabilitative could be modified and extended if the circumstances by which it was supposed to fix do not occur. So if you're paying rehab alimony so that your spouse can get training and get a new job, and she doesn't complete the training, then she might be able to extend the rehabilitative alimony, which was just grossly unfair. The limited duration that we talked about a moment ago could not be extended in duration. It could only be extended or increased in amounts during the course of the alimony payment. I actually was the lead attorney arguing the case that made that law. So I forget the name, but if you're interested in limited durational alimony and modifications, just run a word search for that term and my name, and you'll probably come across the lead case that defines it. So there's reimbursement alimony. This is the least common that I see. It's usually it's when there's one spouse that has significantly contributed to the education or training of another. It's usually awarded when there's no other reason to give alimony. The theory is if you help your spouse obtain an advanced degree, like a medical degree, for instance, and he or she is now earning a ton of money and then you get divorced, you can't get alimony because you don't fit the statutory criteria. But you gave that person an asset that they're taking out of the marriage. So reimbursement alimony, I think, was intended to compensate for that loss of the asset that you got that can't otherwise be distributed. So let's talk about the alimony factors. And there's a lot of them. So I'm just going to breeze right through them so that you have them. And that's why I give you the handout so you can just print if you want it. First is the actual need and ability to pay, duration of the marriage, age and physical and emotional health of the parties, standard of living. Again, I remind you that now it's supposed to be a balanced one. Earning capacities, educational levels, length of absence from the job market, usually of the person that's seeking the support, parental responsibilities, time and expense to acquire sufficient education, going back to what I was talking about for a rehabilitative alimony, to either finding appropriate, sometimes it's for training and employment, and other times it's just for the opportunity to acquire assets and income. History of financial and non-financial contributions, that's where raising a child, a lot of people complain that their wife didn't work, so they have to pay alimonies because they raised a family. contributions to the children and education, and also the interruption of their careers, which is important as a side note. A lot of people have, I personally had a spouse who didn't work and didn't raise children or help me in my business and still sought to have alimony awarded, but there was really no financial or non-financial contribution. So it's still going to apply. Don't think just because your spouse doesn't have children that you're going to have an easy way to get out of alimony. It's not going to happen. Equitable distribution of property ordered. I've never really seen that affect alimony. Maybe in a case with significant assets, but otherwise it's not. Income available through investments. Usually it's either dividends and investment income or interest income. Tax treatment for alimony. Now that may be revised under the new tax code revisions. It can include a portion or not of all of it being deductible. Sometimes you can try to agree to a non-deductible alimony in the past. Again, now it's pointless. Nature and amount of PL support, because now under the 2014 reform, if you pay alimony through a divorce or a pendente later through your divorce, it now counts into the length of your alimony. Before it didn't. It's sort of you paid for possibly a year or so while you went through your divorce, and then alimony started and you ran like a whole new term. So like under the open durational laws, for instance, if you're married 5 years, under the new statute, your alimony can't be more than 5 years. But if you have a 2-year divorce, which is unusual, but if you have a 2-year divorce, those 2 years now count in the alimony. You can't pay more than 3 years. And there's always a catch-all about any other factors the court deems relevant. Now, in my opinion, these factors are generally not used. First of all, there's a 1/3 rule that you'll hear about. I'm not going to go through, but that's most commonly how people start alimony analysis, taking 1/3 of the difference. But in my opinion, the most important 4 factors that the court looks to when it comes to alimony factors is the length of your marriage, the standard of living, the higher earning spouse's ability to pay, and the lower earning spouse's ability to earn. Those are the 4 most important factors that you want to focus on. Now moving on to modification termination, the slides are a little messed up on this one. So the Lepus and Cruz are the 2 most important cases that deal with modification and termination of alimony. Generally, change of circumstances, income, health, disability, employment would be grounds for it. These cases are generally going to be put into your agreement for alimony. I call it sort of a double-edged sword because you want to put in that alimony can't be increased if you're paying it, but then you also want to put in that if you lose your job, you can decrease it. You can't usually have it both ways. You can't say, well, if I can't pay it, I got to decrease, but if things are improved, I don't have to pay more. It's usually, both parties are going to want it to either be non-modifiable or modifiable. So then if your spouse becomes disabled and needs more money, she can modify too. So you have to balance whether you think there's going to be a change in your circumstance or hers when you decide whether or not you want to put in these Lepus and Cruz standards. Again, the standard is going to be a substantial change of a permanent nature, and you have to decide if it's likely to affect you or her as to whether or not you want that protection or not. It's also permanent and temporary change of circumstances. That's why you have that 90-day window. It used to be 6 months before you could even seek a modification. Anything that's less than 90 days now is considered temporary. So if you lose your job today, they don't expect it. It's not a permanent circumstance until 90 days. That's why you can't even file. You always will have an obligation to get the best, if not better, employment. So I generally say, like I was suggesting earlier, you want to keep and submit resumes when you're seeking a modification. You need to prove the searches that you did for jobs by keeping records of it. You want to keep your status and all records of interviews, of rejection letters, of everything, because it's a very difficult standard. Once you meet that 90-day window, it's very difficult to open up alimony for modification, especially when you're unemployed or even underemployed, because there is an issue about imputation of income. If the court believes that you are voluntarily underemployed or unemployed with no just cause, which is the standard, then they can inflate your income to where it used to be, even if you're not actually making it for purposes of modification, or even for purposes of setting the alimony in the first place. So that's a very difficult thing. Now, if you are facing an imputation of income case, when somebody's arguing that you're unemployed, you're going to need all these records in order to establish that you are in fact working either to your capacity or trying your best to find a job at that level. Moving on, for more information about the new statute, it was intended to provide better clarity for judges. The problem, like I was saying when we first started, is that there were a lot of issues in how people were practicing, both lawyers and judges, that weren't really in the statute, so they attempted to codify it. And, you know, they wanted uniformity of decisions because things that greatly impact all alimony decisions, both setting the alimony and modifying it, is when you have other children. You might have a remarriage or a blended family, changing their needs, both yours, your family's. College was a huge issue, or it still is a huge issue, because child support doesn't apply to college, but you also have a college or a child support obligation at the same time you may have college obligation. Remarriage is going to significantly impact you. Now, under the new statute, if you're self-employed or not, the standards are different. Your proof levels are different. Remedies for temporary and permanent alimony was ambiguous, so they're trying to codify that. Retirement was unclear. I told you about the catch-22. Now there's a presumption at 65, as well as the anticipatory right to retire. Now, and there were different standards before the last statute, before the revisions. Now, moving in cohabitation. Cohabitation is obviously a huge issue when you're paying alimony. In my opinion, the change made it easier to prove cohabitation. Here are the factors that the court's supposed to consider is, and this existed before the statute also, but intertwined finances. The parties are sharing joint responsibilities for living expenses, meaning paying the same bills, having joint bills come to the house. Recognition as a family in society. Living together, frequency of contact, other suggestions that they were mutually supporting one another in an intimate relationship. Household chores, whether there's a promise of support, like an engagement, or even maybe sometimes there's an estate plan, like somebody drafts a will. Other relevant evidence, the length of the relationship. And one important thing they also put into the new statute now is that the court can't say there's no cohabitation simply because they don't live together, meaning living together is not the only proof. You can live in different places now and still be cohabitating for the purpose of these other factors. You're sharing expenses. You're recognized in society. If you're spending a lot of time and weekends and overnights together, but you're maintaining two different places, that still may be cohabitation. So the things that you need to do to prove cohabitation, and you have to be careful because cohabitation is very difficult to prove. And one point I want to tell you real quick, because I don't think it's actually in the slides. Another change they made about cohabitation, one of the things they changed negatively about cohabitation that did not exist before the 2014 change was before, if you could prove cohabitation, your alimony obligation was either modified or terminated. And that was the end of the discussion. Now, if the cohabitation ceases after your alimony is modified or even terminated, the supporting spouse may be able to return and seek the reinstatement of the alimony award, which I think is atrocious because it allows people to sort of play games with cohabitation, because cohabitation is very difficult. I'll tell you in a minute why it can be difficult to prove, because you'll see what you need to do to prove it. And then you have to go through usually a lot of litigation in order to establish it, which can be financially devastating. And then once you're successful and your alimony is modified or terminated, your ex-wife says to her boyfriend, we'll move out for a couple months and I'll get my alimony put back in. And then they do that, and then they cohabitate again and put you right back in the same spot. So this is another thing that I have not seen brought to the appellate division yet, because the statute is still relatively new. But it's going to be a big issue and a lot of problems for people. So keep an eye on this when you're making cohabitation agreements in your divorce cases. So what do you need to prove cohabitation? First of all, surveillance is usually the best. And I don't recommend that you do it yourself, because that could be stalking. You want to hire somebody not only to avoid the stalking issue, but also so that you have a professional, you have proofs like pictures and a report and somebody who can testify that's not biased. Well, I guess they would be biased because you're probably paying them, but they'd be less biased than you will be and more believable. The problem with that is it can be very expensive. The people I know that do this kind of work generally charge between $85 and $285 an hour. And if you need them to sit out all night long or all weekend or days at a time, it can be very costly. I do work with some people who do what's called a pole camera, where they attach a camera across the street somewhere and it takes pictures just all day long. Then they go through the pictures to see when people are coming in and out and who's doing household chores and things like that. That's a better, lower cost way to prove cohabitation because you don't have somebody sitting there all day, but you get a little less insight because you're only seeing pictures. So you're not really finding out what's in their trash, if they have shared expenses. You don't have somebody that might see into the window if they're doing household chores, but it's a balance. But surveillance of some kind is going to be your most important and most helpful. Use of GPS tracking devices is good, but you got to be careful again. Don't do this yourself. There is abundance of case law that suggests that if you place a GPS device on your spouse's or ex-spouse's car, that it is a form of stalking, and you can and will get a restraining order issued against you if it's discovered. But ironically, if you hire a private investigator who puts the GPS device on for the purpose of litigation, I don't believe they can then impact or impart a restraining order upon you. So always do it with the use of a professional. You want to try to subpoena bank records, lease agreements, utility bills. This is difficult because if you're not in litigation, you don't have subpoena power. Even an attorney does it. You more often than not need to ask for post-judgment discovery, or you need to find some other mechanism to obtain these records. Again, there are private investigators who can do bank searches for you. And the problem in this area, and most of the problem with cohabitation, is the things that the statute states are the factors for the court to look at are not common in today's practice. Like they look for shared expenses, shared utilities, joint bank accounts. A lot of people don't, even married people don't have joint bank accounts. Nobody ever moves in and puts their name on the FiOS bill because you have FiOS, it's your cable, it's your internet, it's your cell phone. So you have the one expense and you just move in and start paying it. People don't change these things. And these are the indicia that the courts are looking for most commonly because all the judges are much older than the practitioners and most of the litigants. So those that have their internet bunches, judges don't necessarily have that. So I don't think, like I said in the beginning of this, that the people have really caught up to the changes in technology or even the changes in the law yet. But going back, so background checks on both people, if you can get, again, somebody, usually a private investigator, to search like driver's license, their registration on their utilities for what address it's going to, whether mail is being forwarded to or being received. You can certainly try to interview friends and family and neighbors. That could be tricky for obvious reasons. But if you can get somebody who's not only willing to tell you but willing to testify or sign a certification, certainly helpful. Social media is becoming a much better area because it's so prevalent. There's so many sources that a lot of people don't realize how much information they're really putting up on the social media. So now if you're going into a cohabitation case now, and these factors will actually even help you if you're in a divorce now and you want to put a cohabitation clause into your settlement agreement. You want to plan ahead. So there's certain options, like you could consider avoiding a lump sum alimony. Often people want to buy themselves out of an alimony agreement because they don't want to have an obligation, or because they might think it's easier to give a lump sum and shift the taxes and be done with it. I think instead, maybe look to a lesser amount with a longer duration so that you're still getting that benefit. And a lot of people do it because it's incentive for the spouse to end the case more quickly, which is sometimes very important to the person who's going to pay alimony. But I think it's tricky because if you pay lump sum and the person remarries the next week, you've lost out on your ability to terminate alimony. And I saw a case where somebody got married the same day that they got divorced in the same court. Now, there wasn't any alimony. My point is that it can be done and it happens. So advanced lump sum alimony is usually not the best thing. If you want to pay alimony, if you have the money paid in advance, stick it into an account and just pay it out of that account. Consider the waiver of cohabitation provision as incentive to get a concession. A lot of women don't want the cohabitation clause. Truthfully, it's not in your best interest always to have it because it's very difficult to prove and very costly. So you might be able to get lower alimony by giving up the cohabitation clause. But remember, if they cohabitate, you don't get the terminate alimony. So you have to balance that. You could negotiate a specific term defining cohabitation. Remember, I was saying that the courts really have not caught up to how things are. So part of what we try to do in our practice, because we represent men's and fathers' rights, is to draft a cohabitation term that's more realistic, so that if we do have reason to believe they're cohabitating in the future, our definition is utilized and makes it much easier to establish a cohabitation. So you also want to negotiate, and if you can get that, that's great, but you also want to have that they have an affirmative obligation to tell you, meaning if they move in their fiance or their partner, they have to tell you. And what that triggers is if they don't tell you and you file for the modification, then you can ask for the retroactive adjustment back to the date that the cohabitation actually began, not the date you found out about it. And you can also possibly get some, in addition to getting your support back, you might also get counsel fees because of bad faith. Another thing I routinely try to put into all of my agreements, not even just for cohabitation, but anytime there's an alimony obligation or a sizable child support obligation, is the right to go to mediation or arbitration in the future. Because as I keep saying about cohabitation and modification, the standard to get into court is very challenging. Not only did I outline what you need to prove and your 90-day waiting period for modification and all the surveillance that you need for cohabitation, but the problem about the litigation itself is once you get to this, once you've either waited 90 days or you have all this evidence for cohabitation and you're still paying the alimony all this time, mind you, you then file your motion to modify. That's going to be heard in a month or 2 or 3. Now you're out 6 months. If you're successful, all you've got from the court is the right to have a trial to determine how your support is modified. Because cohabitation doesn't necessarily mean elimination unless it's in your agreement that way. So now you're 6 months out. Now you have a trial, which is it's like a mini divorce case. You're going to have discovery periods. You're going to have case management. You're going to have early settlement panels. You're going to have close to 8 or 12 more months of litigation. Not only are you now continuing to pay the support all of this time, and getting it back is difficult because most people spend what they earn, but you're spending all this time in legal fees. You're spending all this losing time from work, your time away from your kids. I mean, the financial and emotional cost of a modification or cohabitation litigation is so draining that a lot of people don't even bother going for it. A lot of times it doesn't even make sense because you're not going to save more than you're going to spend. But if you put in your provision that it's mandatory that you go to mediation, or even better for arbitration, then you have a faster, more expedited, less formal process to resolve the difference. I like arbitration because arbitration gives you a decision. Mediation is just you try to make an agreement. If you don't reach one, it's over. Arbitration gives you a decision. I generally do it with a retired family court judge. So you get the same type of legal analysis and decision and expertise, but you don't spend the time of going through litigation and trying to get a trial date, which is generally impossible. Arbitration, you can be done in 3 months, 4 months, and it's a world of difference. That's all I have. We're at about our 50-minute mark. I'm going to take a minute to see if there are any questions. I'm going to open my chat panel, see if there is anything. Wow, I actually don't see any. I don't know if that means I just covered everything well or that I didn't cover it at all, but hopefully it's covered well. If not, you can always contact me. Again, my phone number is 973-562-0100. My email is right here for you, brad@micklinlaw.com. Our address, once again, 187 Washington, Suite 2F, Nutley, New Jersey. My YouTube page, if you want to get my daily tips and my how-to videos. I try to do a how-to video every week. Is Brad Micklin. It's Micklin. And with that, I'm going to wish you a good night and hopefully we'll see you in 2 months when we do our next one. Thank you.